All rise. Council second floor down session. Judge Steve Lawson.
Thank you. Please be seated. Right. Good afternoon. At this time, let the record reflect we're taking up two actions. We're taking up Commonwealth of Kentucky versus Joseph Lawson. That's case numbers 23 CR 183 and 23 CR 239. Both of his attorneys are present here in the courtroom, Mr. Coleman and Mr. Boyd. We have Mr. Lawson on Zoom. Mr. Lawson, can you hear us?
Yes, sir.
Very good. If at any point you can't hear anything, you let me know. Mr. Lawson is present on Zoom from the Grayson County Detention Center. We're also taking up Commonwealth of Kentucky versus Stephen Eugene Lawson. It's 23 CR 165 and 23 CR 371. Mr. Lawson is present with counsel, Mr. Lavitt. Also present on behalf of the Commonwealth is Special Prosecutors Ms. Young and Mr. Lasowski. By way of background, I believe both of Mr. Joseph Lawson's cases came before the court back on July 18th. On that date, the matter was continued to today's date so they could consider the decision of Steve Lawson in regard to Kentucky Rule of Evidence 410. In regard to Steve Lawson's case, back on July the 3rd, 2024, this court entered an order, and in that order, the court noted that on today's date, the defendant shall inform the court as to whether he wishes to use or exclude the interviews that were conducted in this case. After that, it appears that Mr. Lavitt filed a motion or filed a response on yesterday's date in which Mr. Lavitt doesn't wish to provide an answer to that question. Would that be correct, Mr. Lavitt? Mr. Lawson, why are you holding your hand up for?
To ask you a question, sir. Nigga, probably stand up and say something to the court, sir.
Okay, well, what is it you're wanting to say? But let me remind you, everything that you're saying here is being recorded and it could be used against you. Do you understand? Okay, well, what is it that you're wanting to say?
It's come to my attention. I don't think I'm trying to knock nobody. My attorney's doing his job for me anymore. I can't use this, I don't know what you call it. It's counsel anymore, sir.
I'm sorry, I didn't
I
understand.
can't use his counsel anymore, sir.
Okay, are you saying that you're wanting a different attorney?
Yes, sir, that's exactly what I'm saying, sir.
Okay,
I'm sorry that I didn't make myself clear. I apologize.
okay. Are you able to afford it?
Not right this second, no, sir.
Okay. So you're wanting to discharge Mr. Lavitt, is that right?
Yes, sir, I am.
Does the Commonwealth have any objection to that?
No, sir, we do not. As a matter of fact, Judge, we have serious concerns about whether Mr. Lawson has had conflict-free counsel in his representation. I have been privy, obviously the court is aware, as I think the parties are, that the jail calls are regularly monitored of the defendants in this case. On August the 4th, there was a jail call that Mr. Lawson had with his family in which he said he had already fired Mr. Lavitt and told him that he no longer required his services because Mr. Lavitt had been meeting with Brooks Houck's attorneys behind his back and had admitted that to him. And that he did not want to continue with him. So I can tell the court that I was surprised yesterday when we got a response from Mr. Lavitt on this motion because I had assumed that he would file a motion to withdraw on this case and would have informed the court that his client no longer wanted him to represent him. I previously informed this court in the pleadings that we filed in this case, in particular, Mr. Lawson's, the response to Mr. Lawson's motion for immunity, that there is a peculiarity going all the way back to March between these two defendants and the motions that they have filed or the pleadings that they've filed in this case. Where we have 190,000 words that have been spoken in the interviews with Steve Lawson And they both managed to pull out the exact same quotes out of the interviews to put in each of their motions. Some of them are not even supportive of Mr. Lawson's claim for immunity. I'm not even sure why the quote would be in there. But they also contain the same misquotes in each motion. They contain the same paraphrasing of people's statements in each motion. They contain the same, such and such walked in the room. They're phrased exactly the same. And it defies reason that they would be exactly the same. And I cannot get any scenario in my head where an immunity motion on behalf of Mr. Lawson, in which he has to claim that everything that he spoke in those interviews was 100% the truth, could in any way be in a collaborative effort with Brooks Houck, or Brooks Houck's attorneys, since he obviously gave us information about Brooks Houck, and he would have to affirm that. And I think we saw that when we had the hearing on those motions. Mr. Lavitt couldn't even tell the court what was in his own motion on that date. And he did nothing to affirm that Mr. Lawson had told 100% the truth. He put on no evidence. There was nothing put forth on that date. And after that hearing, in which he sat here and told the court that his client did tell the truth, eventually told the court that he went around and around and around that, he walked out of his courtroom and gave a press conference in which he spouted Brooks Houck's defense again, that Steve Lawson was told what to say in those interviews, and essentially said he didn't tell 100% the truth. I don't know what's going on here, but I know that it's something that I think the court needs to inquire about. It's disturbing. I'm not sure that Mr. Lawson has received conflict-free counsel. I'm not sure that he has had what he's entitled to under the Sixth Amendment.
Mr. Lavitt, do you have any response?
Yeah, if I can respond briefly, Judge. I arranged for a meeting with my client, Steve Lawson, this past week. Went over to see him in the jail here in Nelson County, and he was in a good frame of mind, a good humor. I explained what we were going to be doing here today at 1:30. He told me he understood it because I went over it with him twice. He has never called my office and told me personally that he wished to discharge me or that there was any conflict of any kind. So I have done my best at this point in time without any conflict whatsoever concerning my client. And I believe that Mr. Lawson has been aware of what I've been doing on his behalf since he engaged. That's all I have to say, Judge, unless the court has some questions for me.
Mr. Levin said here today to change your mind as well.
No, sir, Your Honor, has not. I apologize for wasting your time.
Okay, so you want to have a public defender appointed for you?
Yes, and I see what I cannot do, sir. Yes,
Okay.
please.
At this time, the court is going to find that Mr. Lawson has requested to discharge his attorney here today, and I'm going to show that his request is granted. I'm going to show that DPA is to appoint an attorney to represent Mr. Lawson. I want Mr. Coleman, if you can let them know upstairs, I need an attorney here in 2 weeks, August 22nd. I want to find out who's going to be representing Mr. Lawson because we've got a trial date in February and I plan on moving forward. So I need to get somebody on board that's ready to go.
Is it a time on August 22nd?
Let me see if I've got an afternoon time available so I can finish my morning docket that day.
I imagine if you just ask counsel.
I can do it at 1:30 on August 22nd.
1:30?
If that's all right with everybody else as far as the time on that.
Yes, sir.
Okay. Okay, then I'm going to put this on for August 22nd at 1:30 so we can have a new attorney represent Mr. Lawson. And at that time, I'm hoping we can set some scheduling for that new attorney to determine how they wish to proceed under Rule 14. Okay? Anything else we need to take up at this time? Yes, Mr. Wasowski?
Yes, we'd ask that, Mr. Lavitt, as soon as there is an identified, attorney to represent, Steve, that he get all the discovery, delivered to that person as soon as possible. Same thing you're saying, so that they can be prepared to decide in case at the appropriate time.
Any objection that Mr. Lavitt turn over your file to the new attorney?
Without objection.
Okay, I'll show then, if you'll tender an order, Mr. Wasowski, that Mr. Lavitt is to turn over his file to whoever is appointed by DPA as conflict counsel in this case.
I'll prepare that as an agreed order, today or tomorrow.
Okay, that'd be fine. You can email it to me and I'll get it entered as soon as I get it sent to.
Appreciate it.
All right, anything else you need to take up at this time?
That was-
All right, thank you all.